I want to talk about a legal change that came into effect on 19th of June 2026. And if you sell anything online to consumers in the European Union, there is a reasonable chance that this affects your business. What's interesting is that almost nobody is talking about it. Everybody's still talking about AI. Everybody is talking about economic uncertainty and how the market's changing. Everyone is talking about growth. Meanwhile, one of the most significant consumer law changes in years has arrived and no one's talking about it. I am talking about the EU Directive 2023/2673. Now I know what you're thinking, well that sounds incredibly boring and I have no idea what it is, but bear with me because by the end of this video you'll understand why this matters to online businesses, software companies, membership businesses, subscription businesses, financial services providers and really anybody that's selling remotely to consumers in the EU. What's fascinating about this change is that most people are describing it as the withdrawal button law. You've maybe heard of that. And whilst that's not technically its name, that description has stuck because it gets to the heart of what regulators are trying to actually achieve. They are trying to make it just as easy to get out of a contract as it is to actually get into one in the first place. And if we're honest, that's not how many businesses have been traditionally operating over the last few years. Think about how easy it is to subscribe to things today. You just click a button. You enter your details, you confirm payment method, and you're done. 30 seconds later, you've signed up to something. Now think about how many businesses make it really difficult to leave. You have to email their support team or fill in a form. You have to wait for a response to confirm. You have to call a phone number. You have to navigate 3 different pages to cancel. You have to remember a password that you haven't used in 2 years. The European Union has effectively looked at that and they've said, no, if consumers can enter a contract online, they should be able to leave it online. That is the principle behind this piece of legislation. Now, before we get into the withdrawal button itself, let's understand what this directive actually is. The directive was primarily introduced to modernise consumer protection rules for financial services sold at a distance. The previous rules dated back more than 20 years. Before smartphones existed, before we had fintech, before online first banking, before many of the digital financial products that we take for granted today. The EU essentially concluded that the old framework was no longer fit for purpose and needed to be updated for a digital economy, what we're living in today. So one part of the directive focuses on financial services, but another part has attracted enormous attention because it amends the Consumer Rights Directive and it includes a new online withdrawal function. And this is where businesses are starting to have to pay attention. Historically, customers have had withdrawal rights in many distance selling situations. In simple terms, consumers often have a cooling off period. It's usually 14 days. They can change their mind and they can withdraw from the contract and they don't have to give a reason for that withdrawal. The right itself is not new. The mechanism is. The EU has essentially said that if consumers entered the contract through an online interface, businesses should provide an online mechanism allowing them to withdraw through that same initial interface. In other words, if the customer signed up online, they should be able to withdraw online. Simple, right? But potentially quite significant for online businesses. The legislation actually goes into a surprising amount of detail. The withdrawal function must be easy to find, it must remain available throughout the withdrawal period, it must be clearly visible to customers, it must be easily accessible to customers, and businesses must provide an acknowledgement of receipt once a withdrawal request has been submitted by that customer. What's really interesting is the philosophy behind all of this. For years, consumer law focused heavily on information. Give consumers enough information and they will make informed decisions. This directive recognises that information alone isn't actually enough. Behavioural design matters. User experience matters. How websites are built matters, because businesses can influence behaviour through design. The EU has become increasingly focused on what are often called these dark patterns, design choices that nudge customers towards outcomes that benefit the business rather than the consumer, making cancellation difficult, making withdrawal from services confusing, making renewal easy but termination difficult. The new rules are designed to reduce these practices. And I think that's where founders should really be paying attention, because this isn't just another legal change. It's part of a broader regulatory trend that we're seeing. The direction of travel is really, really clear. Regulators are increasingly expecting businesses to act fairly, transparently, and in a way that allows consumers to make genuinely informed choices. And if your business model depends on customers struggling to cancel, that's going to become a much riskier strategy for you. Now let's talk about the financial services side, because that has received way less attention, but is arguably just as important as this withdrawal button. So the directive introduces enhanced information requirements for financial services that are sold remotely. Consumers must receive clearer information before they're entering into contracts. There are stronger rules around withdrawal rights, additional reminders in certain circumstances, enhanced protections for consumers engaging with financial products online. Again, the theme is consistent. More transparency, more consumer control, less friction when consumers wish to exercise their rights. One thing I find fascinating is how many businesses still think consumer law only matters to large retailers. It doesn't. A software company selling subscriptions can be affected. A coaching business selling online programs can be affected. A membership organisation can be affected. A fintech company can be affected. A professional services business selling directly to consumers can be affected. Consumer law increasingly sits across almost every industry, and that is why this matters and why it is so important. Now let's talk about the practical question every founder is asking. What happens if you don't comply with this? Well, the answer will depend on the jurisdiction and the particular circumstances. But generally speaking, non-compliance can create several problems for you as a business. Regulatory investigations is the first one, consumer complaints, enforcement action, potential fines, extended withdrawal periods in certain circumstances, and perhaps most importantly, reputational damage. Because one thing we've learned over the last decade is that compliance failures rarely stay private. Customers talk. Customers post online, customers contact regulators, and what begins as a technical compliance issue can quickly become a brand issue. If I owned an online business selling into the EU today, I would be asking 5 questions as a founder. Firstly, do consumers have a statutory withdrawal right? Secondly, if they do have that right, can they exercise it online? Thirdly, how easy is it to find that function? Fourthly, what acknowledgement process exists once withdrawal has been requested? And fifth and finally, have our consumer-facing terms actually been reviewed recently? Because many businesses are relying on terms drafted years ago, before these changes were ever contemplated. The final point I'd leave you with is this. I don't think this directive is really about withdrawal buttons. I think it's about something much bigger than that. It's about a shift in regulatory thinking. Historically, businesses often focused on getting consumers into contracts. Increasingly, regulators are focusing on consumers getting out of contracts, and those two objectives don't always neatly align. The businesses that succeed over the next decade won't just be the businesses with the best products. They'll be the businesses that build trust. They'll be the businesses that operate transparently, and they'll be the businesses that recognise consumer protection is no longer a peripheral compliance issue. It's becoming a core part of doing business. And this new directive is one of the clearest examples of that trend that we have seen in years.